Welcome everyone. We're so glad to have you here today. Welcome to the third annual Interfaith and LGBT Summit on Religious Liberty and Employment Non-Discrimination. My name is Tanner Bean. I'm the chair of this year's Summit Organizing Committee, and I am happy to speak to you today just to open things up. I don't want to take too much time away from our panelists because we're excited to have them here as well as have you here. We're excited to have such a great turnout as well this year, even amidst the pandemic and the challenges that have been layered on top of other challenges that different communities face. We note that some of those challenges disproportionately affect some communities, and perhaps that's something that we will discuss today. However, with the light at the end of the tunnel on the pandemic, cross our fingers, we hope that we'll be able to resume this summit next year in person, or at least in a hybrid experience. Today we are joined by a diverse panel of speakers, as well as a diverse audience. And many of us have ties, history, and personal experience with faith, religious organizations, and belief. Many of us can speak to lived experiences of discrimination, isolation, and rejection. Many of us are members of the LGBTQ community, are allies for gay, lesbian, transgender, and queer individuals, and affirm that love extends to all. Many of us have had all of those experiences. Now this year, as the summit's subtitle suggests, our focus is on the workplace discrimination, workplace cultures and inclusion initiatives, open legal questions, the needs for accommodation for faith, orientation, identity, and so on. Our discussion today is going to provide us with insights from the panelists observed from the different vantage points that they have. And we hope that this discussion today causes you to think about something in a new light, to consider something you hadn't thought about before, and maybe to take action in a way that you hadn't considered. The purpose of the Interfaith and LGBT Summit is fourfold. It has been since the founding of the summit. First, to acknowledge common ground between the faith and LGBT communities that both want to live their lives openly according to their sincerely held convictions. Second, to explore ways that both communities can do so without coming into conflict, both socially and legally. Three, to educate and empower community leaders and community members to support religious freedom and non-discrimination in their own spheres. And four, to influence Idaho policy and legislation where gaps for religious freedom and LGBTQ non-discrimination remain. So we hope today that this discussion provides some of the groundwork needed for the legwork in Idaho that remains on these issues. Briefly, before we jump into our discussion, I wanted to recognize this year's organizing committee members. They have put in a lot of precious time into planning this event, and so I want to thank them publicly. Our first member, and if you want to give a hello and a wave, committee members, that'd be great so people can see your face. Our first committee member is Spencer Felton. He is in the leadership of the University of Idaho College of Law's chapter of the J. Reuben Clark Law Society. Thanks, Spencer. Next, we have Chelsea Gona Lincoln. She is the chair of Add the Words Idaho. Followed by that is Rich Gardner. He's the treasurer of the Boise, Idaho chapter of the J. Reuben Clark Law Society. Britt Krameyer, she is the outgoing chair of the diversity section of the Idaho State Bar. And then I serve as chair as well on that committee. If you have any interest after our discussion in joining the committee or lending a hand to the planning of the summit anyway, please reach out to us. We'd be happy to talk with you about that. I'd also want to recognize this year's partners in this summit, various organizations that have lent a hand and have joined forces with us. Those include Add the Words Idaho, the American Unity Fund, the diversity section of the Idaho State Bar, the Fairness for All Initiative, the Religious Freedom and Business Foundation, the University of Idaho College of Law chapter of the Federalist Society, the University of Idaho College of Law, and the J. Reuben Clark Law Society. We thank all of those organizations for their support today. Just a few housekeeping items for everyone on the call. First, if you are an attorney and would like CLE credit, we have gathered your information typically through the registration link. But to confirm your attendance today, we also need you to place in the chat your name and bar number. So if you would please do that in the chat. If for some reason you don't want to put it in the chat, feel free to respond to one of the emails in which you received your attendee link to this with your name and bar number, and that will confirm to us so we can get that back to the bar. We expect that it will be processed for 1.5 credits of CLE. Leading into that, during this event, the chat feature will be open. However, for questions, we ask that you use the Q&A feature, which you should be able to view at the bottom of your screen. If there's not another way for you to figure out how to answer your question, that can be placed in the chat feature as well, and we'll try to catch that and bring it over. This event will be recorded, as you have likely noticed. As such, we ask that attendees stay muted with the cameras off. In fact, you may not even have the option to change that. And this recording will be made available on the Summit website in the days after the Summit. As you can see, we do have Summit closed captioning available for those that would like to view it. However, if you would not like to view those any longer and would just like to view the video, you can go at the bottom of your Zoom screen, and there should be a feature that says CC live transcript underneath, and you should be able to hide the closed captioning if you would like. Without any further ado, I'd like to jump into things and introduce our moderator, Rebecca Coudet. Rebecca is the Director of Student Affairs at University of Idaho College of Law's Boise campus. And I will direct you to her full bio at the Summit website. I believe a link to that has been dropped into the chat. If not, we can drop another link. But I can just say that she's had a very interesting and broad-ranging career with experiences in the judiciary, tribal prosecution, the Attorney General's office, county prosecution, appellate practice, and even family law. So we're thankful for her, and she will introduce us to the remainder of our panelists. So with that, Rebecca, I will turn the time over to you. Thanks.
Thank you, Tanner. Hello and welcome. I can't emphasize enough how excited I am to be a part of this conversation. Often the demands of my work with students at the College of Law don't allow me to engage in a deep dive with current legal issues anymore. So the lawyer side of me doesn't get engaged that much. But the nature of my work demands that I do my best to foster exactly the kind of understanding between sometimes disparate communities that we are seeking to achieve here. So to that end, the theme of the 2021 Interfaith Summit is protecting faith preference and identity in the workplace. So we've brought together Idaho leaders and scholars to discuss how to build an inclusive workplace for both the LGBT and faith communities. Our speakers today will focus on the presence of religious and LGBT discrimination in our society, and specifically on how non-discrimination laws in the workplace interact with religious liberty. In particular, many will be talking about the impact of Title VII of the Civil Rights Act and the US Supreme Court's opinion last year in Bostock versus Clayton County, Georgia. Just briefly, our speakers will go into this more particularly. Title VII prohibits employment discrimination based on religion. And Title VII also prohibits an employer to discriminate against an individual because of the individual's sex. In Bostock versus Clayton County, the court found that discrimination on the basis of one's sexual orientation or transgender status is discrimination because of sex. And now I would like to briefly introduce our panelists. I want to encourage again, as Tanner did, to encourage you to view their full bios on the Summit's website. Dropped a link into the chat. It's way up at the top, but hopefully you'll be able to see it. Ooh, I'll do it again. Just because I enjoyed learning more about our speakers, and you can view that at your leisure. But briefly, we have Kim Clark, who serves as Senior Staff Attorney for Reproductive Rights, Health and Justice at Legal Voice. John Rummel is a professor at the University of Idaho College of Law. Richie Eppink is the legal director of ACLU Idaho. Doug Ricks is an Idaho State Senator representing District 34. Misty Tolman is the Idaho State Director for Planned Parenthood Votes Northwest and Hawaii. Tyler Deaton is the Senior Advisor to American Unity Fund. And Brian Grimm is President of the Religious Freedom and Business Foundation. What we'll do is we'll first start with a short presentation by each panelist designed to give us some insight into the issues and considerations underlying today's discussion. And afterwards, we'll open it up for questions for the panel. So for that short presentation, we will begin with Kim Clark.
Great. Thank you so much. It's really a pleasure to be here. I was asked to talk about the Supreme Court decision in Bostock versus Clayton County. But in the spirit of coming together, I'm going to do something that I don't normally do and begin with a personal story to frame my comments on that case. In 1985, I moved to a new high school where I found it somewhat difficult to make friends. I was very lucky, though, to meet one friend, one true friend, who is the kind of person that you want to just keep around you for a lifetime. Unfortunately, I did something our junior year that really jeopardized that friendship. This friend and I were partners in a moot court competition. And we were very competitive with the other team, which of course happened to be a team of boys. Perhaps they felt threatened by us. They definitely should have felt threatened by us. They had good reason to. But because of that, these boys started calling us lesbians. Suffice it to say that my reaction was less than graceful. I would have said at the time that I supported gay rights and the right of every person to live their life with dignity and to be who they are. But when push came to shove and I was personally called a lesbian, the truth was that I was deeply offended and I let everyone know it, including my friend. And then, even then, I like to think anyway that I didn't feel great about my response. But it was not until 7 years later, in 1992, that I fully understood the harm that I had caused. I remember exactly where I was in my law school dorm room when this dear friend of mine from high school, who fortunately is still in my life, called to tell me that she was in a loving relationship with a woman who is now her wife, by the way. It hit me then like a ton of bricks that despite what I said that I valued, the rules that I said that I was trying to live by for myself, my actions did not reflect those values. Did I see that in 1985? No. Did I see it in 1992? Yes. And of course, I apologized then, and I've apologized many times since then, including earlier this week when I called her to ask if I could tell this story. But I bring this up because it's the same kind of delayed recognition that the way we're applying the rules that we have decided for ourselves that we would live by doesn't necessarily comport with those rules themselves, that also happens in the law. So Title VII of the Civil Rights of 1964 prohibits discrimination in employment because of sex, among other things. But for years after the passage of the statute, courts were still upholding practices that we now clearly recognize as discrimination because of sex. Could an employer refuse to hire a woman because she has children, but offer the same job to a man with children? Could an employer designate some jobs for men and other jobs for women in its advertising? Could an employer fire a woman for being too feminine or for not being feminine enough, or a man for being too feminine? Could a man bring a claim for sexual harassment or sex discrimination, period? We can look back now and say that clearly, yes, all of these are examples of discrimination because of sex. But each of these questions in their time, which was well after 1964, were hotly debated. Why? The meaning of the words "because of sex" has not changed, nor was there any major change in the judicial philosophy of those sitting on the bench. If anything, the judicial philosophy of those on the court has become more conservative, had become more conservative by the time that those particular issues were resolved. What changed was our ability as a society to recognize these practices for what they were all along. Why didn't we see it right away? Think about it. Notions of traditional gender roles have been so deeply rooted in our culture for centuries that we've come to accept them as a given. It takes time to unravel that kind of conditioning and even begin to notice the many ways in which sex informs how we treat one another. In short, it can take time to recognize how certain practices actually conflict with the rules that we set for ourselves, and to see the implications of the law that we didn't previously see. And that is what led to the decision of the Supreme Court in Bostock versus Clayton County. Bostock versus Clayton County, of course, is the decision from this past Supreme Court session in which the Supreme Court held that the prohibition in Title VII against discrimination because of sex necessarily extends to discrimination on the basis of sexual orientation and gender identity. And the opinion is really quite straightforward. Justice Gorsuch, who is celebrated as an originalist and a textualist in the tradition of the late Justice Antonin Scalia, wrote the opinion of the court, and it really, the reasoning is basically this. Whether an adverse employment action was because of sex boils down to one simple question. If all the facts were the same, but you changed the sex of the employee, would the outcome have been different? If so, the action was taken because of sex. If you look at all of the cases that grapple with this question, that's what it boils down to. So firing a male employee because he is attracted to men is unlawful unless the employer would fire a female employee who is attracted to men. Likewise, firing an employee who is assigned male at birth but identifies and presents as female is unlawful unless the employee would fire an employee who is assigned female at birth and identifies and presents as female. That Congress may not have foreseen this outcome in 1964 is absolutely irrelevant, where the unambiguous meaning of the words of the statute inexorably lead to this conclusion. Even Scalia would agree that you don't look to the intent of the legislature unless the words of the statute are ambiguous. And that's how it should be. An approach to textualism that ignores the language of the statute and tethers itself to a particular moment in time doesn't allow for the possibility of introspection and growth. That we might come to recognize how certain practices don't accord with the rules that we've set for ourselves. And that those who claim to be textualists can reach such different conclusions. In this case, Justice Gorsuch, who wrote the opinion, the majority opinion in Bostock, and Justice Alito, who wrote the dissent, both would refer to themselves as textualists. That they can reach such different conclusions, to me, really lays bare the bankruptcy, or frankly, the arrogance of the claim that there is one objective truth that some judges, who unlike the rest of us, somehow magically are untainted by their lived experiences, are able to divine. In terms of where we go from here, will there be implications for other areas of the law that borrow from the language of Title VII, such as the Fair Housing Act, Title IX, State Public Accommodations Acts, among others? Almost certainly, and I hope so. And of course, the Supreme Court also left open the question of whether and under what circumstances an employer could seek an exemption to this rule under the Religious Freedom Restoration Act. I think that would be inconsistent with both the language and the intent of RFRA, and would do far more harm than good, including for those concerned with religious freedom. But I welcome a robust debate about that. To summarize my remarks, what I would say is this: we all have blind spots. To be sure, I have blind spots, some of which most certainly relate to religion. But as Adam Grant explains so eloquently in his New York Times bestseller, Think Again, we all need to have the courage, the grace, and most importantly, the humility to continually interrogate, rethink, and refine our ideas and beliefs. That doesn't necessarily mean changing our values, just as the meaning of the law doesn't change. It means challenging whether our beliefs and actions are consistent with those values. That, to me, is not just a matter of statutory interpretation, it's a moral imperative. With that, I will turn it over to the next speaker.
Thank you very much. And our next speaker is Professor John Ramel.
Well, thank you, Rebecca, and thank you, Kim. In particular, Kim, thank you for highlighting from a very broad 30,000-foot view of the growth and evolution that has occurred both in individuals and in our legal systems. And thank you also for setting forth Bostock's holding. I kind of want to pick up where Kim left off, because she did allude at the end of her remarks about this open question that Justice Gorsuch left at the conclusion of his opinion. So I want to talk about that, and then I want to do two other things. I want to talk about existing exemptions or exceptions for religious individuals and organizations that are already existing in the law, and then talk about what, if any, impact that they might have on carving out additional exceptions for religious organizations and individuals vis-a-vis the court's holding in Bostock, which is, of course, that the Title VII's anti-discrimination provisions, particularly its one based on sex, applies as well to sexual orientation and gender identity. And then lastly, I want to perhaps try to talk about what considerations maybe this court ultimately will take if it, as it most likely will reach that question left open by the majority and by Justice Gorsuch in particular at the conclusion of the Bostock opinion. And then if I may just suggest what I think, based on what I understand the law to be, and my values, as well as values held by some others and values that are not held by others, which I think we probably have a fair representation of that divide amongst possibly the panel members and also the attendees. So let me embark on talking about the open question. Right at the close of Justice Gorsuch's opinion, he notes that there are several religious exceptions or religious doctrines rooted mostly in the free exercise clause, but in the religion clauses generally, that were not before the court. As he says, none of those other laws are before us, and we've not had the benefit of adversarial testing about the meaning of their terms, and we do not prejudge any such questions today. And then he goes on to indicate that there are employers that fear that complying with Title VII's requirements and the one enunciated by the court in the Bostock opinion may require those employers to violate their religious convictions. And he indicates that he's deeply concerned about that issue, that he feels that the free exercise of religion enshrined in the Constitution, that guarantee lies at the heart of our pluralistic society, to quote Justice Gorsuch at the end of his opinion. But he ultimately says those are questions that need to wait another day, that there's no religious liberty claim that was before the court at that time, and they're not going to answer the question on this day, and they will wait for further cases, further briefing, and additional disputes to resolve that question. So that's the open question that is so profoundly set forth and literally teed up by Justice Gorsuch in his opinion for the majority. I want to talk a little bit about Title VII and the current religious exemptions and possible exceptions in the law. Of course, Title VII not only prohibits employment discrimination based on protected categories of sex and now sexual orientation and transgender status, but of course race and ethnicity and national origin. But as we all well know and should appreciate, it also prohibits employment discrimination based on religion, and also, where appropriate, based on the need or failure to accommodate one's religious practices, such as in the area of wearing a tie or getting time off to engage in religious observances. So that's the one part of the law that's clearly there now. So we know that Title VII prohibits religious discrimination generally, but there's also a number of provisions that are more germane to the topic that fall into the category of exemptions or exceptions that may currently exist in favor of religious individuals and religious institutions, which might arguably affect a religious employer's need to comply with the Supreme Court's holding in Bostock. So I'll go through them in something of a summary fashion. But the first one you should note, and one that was mentioned by Justice Gorsuch in his opinion, was that Title VII's anti-discrimination provisions are accepted out under Section 2000E1A of Title VII. They should not apply and will not apply to religious corporations, associations, institutions, schools, or societies with respect to the employment of an individual of a particular religion to perform work connected with the carrying out of the operations of that particular religious institution. So we see, at least on the face of Title VII, a carve out where we in effect allow, to a certain degree, religious employers to discriminate on the basis of religion. But though we have to realize that that's been relatively confined to its terms. I think courts have uniformly held that this particular exemption for religious employers to discriminate based on religion, but it is certainly part of the act and is followed, but it doesn't extend to other protected categories. We do not read that exemption, and the courts have uniformly not read that exemption to allow religious organizations under that provision to discriminate on the basis of sex or sexual orientation or color or national origin. Also, courts have delimited that in certain ways. Some religious school employers, you need say a fairly significant connection with the religious institution. We know in varying degrees colleges and universities have ties historically to religious organizations. So we think of the BYUs of the world or the Notre Dames of the world as being very, very closely tied. Or if I can indulge my basketball fantasies, the Gonzagas of the world, tied to Catholic institutions. A little less so with some institutions. You know, Southern Methodist University has that word in its name, but it doesn't seem to be as tied. And so we see those loose connections. So this provision really has been read to require a fairly tight connection with those religious doctrines and religious institutions. We also know that things like curriculum propagation under Section 2002E, and occasionally the notion of a bona fide occupational qualification in those circumstances occasionally are allowed to be protected, although not probably enough to justify discriminatory practices. In addition, we know that these provisions do single out for religious protection the religious institutions, but none of these would seem to be constitute a good basis for religious employers to make inroads on Bostock. So I want to interrupt myself here and ask Rebecca, how much time do I have? I want to bring this in so that I'm not shorting anybody else's time.
You have about 1.5 minutes, John.
I will try. I might go 2, but let's see what happens. Of course, we have a ministerial exception that was solidified in the Hosanna Tabor case and recently expanded in Our Lady of Guadalupe, which basically says that certain employees of religious institutions, they're indeed allowed to not comply with the anti-discrimination laws under federal law if someone falls into that category of being a minister. And of course, Lady of Guadalupe expanded Hosanna Tabor on that score. We've got the Religious Freedom and Restoration Act and many RFRAs, and those, of course, are out there. They protect sincerely held religious beliefs from substantially burdening an individual's free exercise of religion, unless it establishes that they're using the least restrictive mean of compelling that governmental interest. On RFRA, the score there is that there's a significant dispute regarding whether or not that applies to only to government enforcement, whether a private employer can use RFRA as a defense to discrimination. Most courts have said, yes, only when the EEOC enforces the law will the RFRA defense be there. Also, in the Harris Funeral Homes case, the one case that was a companion case to Bostock that was taken up by the court, the Sixth Circuit said that RFRA was not violated by requiring prohibiting discrimination based on sex, and the court said that tolerating an employee's understanding of her sex or gender identity is not tantamount to supporting it. So I'm going to finish. The most significant issue, of course, is the free exercise clause. And so let me quickly summarize that. There's really two approaches here. If you've got a law of neutral application that generally applies to everyone, the courts, dating back to Employment Division versus Smith, the famous peyote use case and unemployment benefits case, the court said, we have never held, per Justice Scalia, that an individual religious belief excuse him or her from complying with an otherwise valid law of general application prohibiting conduct that the state is free to regulate. So that's one view. The other view is, though, if the law is hostile toward religion or discriminates against religion, then we require more. We require that we have a significantly compelling state interest. Here's my view ultimately. I think the emphasis or the possibility of a carve out for religion certainly exists. Justice Gorsuch was very effusive regarding his framing of this question about the rights of religious speakers. We've certainly had recent cases, Masterpiece K, Trinity Lutheran, and Espinoza, that have given a robust interpretation to the free exercise clause in the last few years. And recently in the Fulton case, which I'd love to talk more about, and I commend it to you to listen to the oral argument, the court said, should we revisit? It was one of the questions briefed. Should we revisit Smith versus Employment Division? I ultimately think that the stronger argument is that there will be no carve out. Indeed, there shouldn't be any carve out under existing law. Title VII is a neutral law of general application, albeit interpreted broadly. And so it basically, all it needs is a rational basis, unless the court decides that some other standard, other Smiths, should be applied. There's not the kind of hostility toward religion or discrimination against religion written into that law that might require a compelling governmental interest. And indeed, in J.C. and Roberts, the court found a compelling governmental interest, or darn near found it, regarding just Title VII's protection of discrimination against all classes, not just race, which we, of course, put at the very top of that pinnacle, but gender discrimination. Bottom line for me, ultimately, is that we have this tension here. My view is that religion needs to be respected. But in the employment context, we already have many, many carve-outs for religion. And I think this is a situation where the courts can and should eventually say that LGBT rights under Bostock should be protected, and there should not be a carve-out for religious institutions, albeit the free exercise clause is very important. Rebecca, thank you for indulging me. I appreciate it. Hopefully I haven't gone on too long.
Thank you, Professor Ramel. I appreciate you trying to bring that home as quickly as possible. And to follow up on and expand, next is Richie Epping.
Thanks very much. Hi, everyone. I guess I'm used to, at this point, the fact that I'm talking to, it looks like 150 of you, but can't see any but 3 of you. So I do see some names that I recognize on the list, and so hello to everyone. My vantage point here, I'm a generalist, and when it comes to human rights and civil rights, and for people all across the state, our office is the last and often the only resort that people turn to. And so the people we hear from week in and week out are Idahoans who have been pushed down and pushed out, fired, evicted, excluded, denied, punished, threatened, intimidated, assaulted, brutalized, tortured, locked up, locked away, ignored, abandoned, and silenced. And I've had the privilege of representing Idahoans to ensure their most basic religious freedoms. I've represented Idahoans to vindicate their freedoms of speech and assembly. And I've represented Idahoans who have been discriminated against because of their religion. And I've also represented Idahoans who have been discriminated against because of their most basic identities, including their gender and sexual identities. And so what I get to see, and there are pros and cons to this, I can tell you, what I get to see is the place where law and humanity collide and tear at each other on a day-to-day basis. And in the last year, like many of you, I have spent a whole lot of time looking at my face, more time looking at my face than in any other year of my life. My favorite tweet of the pandemic comes from somebody who goes by Clara on Twitter, and it is, "I am narcissist and my little Zoom square is my lake." And so I've been thinking a lot about mirrors. And in fact, in the last week, I've been thinking even more about mirrors, because another side effect of the pandemic is that some of us, including me, spending a lot more time outdoors, and the outdoors are dangerous sometimes. So I just got stitches out of my face last weekend. And so I've been thinking even more about mirrors. And we spend time looking at ourselves, but when we look at our society, our societal mirrors are a little bit more jagged and distorted. But one of them, for sure, one of those collective mirrors that we have is the law. And I was asked to talk about, what is the framework for actually enforcing these rights for Idahoans, and what do these cases look like? And I am going to talk about one briefly, at least a little bit about one of those cases that I have right now, a Title VII an Idaho Human Rights Act case involving the workplace. But I think to think about that framework when we think about religious freedom and the right for people of all gender identities, all sexual orientations to be themselves at work, that that framework in Idaho in particular involves looking at that collective mirror of the law. It has a really huge impact on all of us, and particularly it has a really huge impact on people who are trans and queer, gay and bisexual and lesbians in the state. In the Supreme Court's decision in Obergefell, the marriage decision, Justice Kennedy talked about this and talked about Bowers, that case where the Supreme Court upheld Georgia's anti-sodomy law, and the court recognized that that decision caused a lot of pain and humiliation, and that those injuries for people all across the country who are gay and lesbian and bi, those injuries lingered, the court said, lingered long after Bowers was overruled by Lawrence in 2003. And the court said dignitary wounds cannot always be healed with the stroke of a pen. And the court, of course, in Lawrence, when it overruled Bowers, talked about moral disapproval not being a justification for a law. And if we look at Idaho's legal history, that history, that collective mirror for people who are queer and trans and gay, lesbian, still has a real effect today. It lingers, those wounds linger just like Bowers lingered long after it was overruled. And we can go back to the 50s and the voice of Boise, to the 90s and Initiative 1, and the last well over a decade now that we have not seen our Human Rights Act amended to add those words, gender identity and sexual orientation. I suspect that Misty Tolman will talk more about that later. And of course, we saw last legislative session, not just not adding those words, but enacting laws that were targeted at people who are transgender in the state, and that are now, well, one of them has been, I think, finally put to bed, the birth certificate law, but the other one, now I'm involved in the challenge at the Ninth Circuit. And so when we look at what it means to enforce these rights, we can look to state statute and look to the state constitution, and I can find there and use the state law that protects my client's freedom of religion, it gets more jagged and distorted of a mirror when I look to them and try to reassure them that the law also protects their most basic identities when it comes to gender identity and sexual orientation. A case that I have right now, a workplace case, a Title VII case, an Idaho human rights case, does involve just that, the most basic act of being who you are and being free to be proud of it. It's actually one of the same issues that was involved in Professor Rommel was talking about the companion cases to Bostock, and one of those 3 cases was Donald Zarda's case, who was a skydiving instructor who mentioned that he was gay to a customer and then was fired. Even in the introduction to the event today, Tanner Bean mentioned that many of us here are, quote, members of the LGBTQ community. And that's just what my client did in my open case as a library worker who identified themselves as, quote, a member of the LGBTQ community while at work. And during Pride Month, no less, the month set aside to recognize the impact of the marginalization that people have experienced because of their gender identity and sexual orientation. During Pride Month, they were punished for asserting their identity at work. I'm not going to say much more about the case because the case remains pending, but part of the thing I want to say here is that the fact that the case does remain pending tells us even more about that jagged mirror that we have in Idaho. We have seen over this decade a number of localities, cities, and Ada County who have adopted non-discrimination ordinances that protect their citizens, and that does have a huge impact when we think about the dignitary harm or the dignitary support that the law can provide. They offer limited help in reality because they offer no private right of action, and they're ultimately, most of them are administered by law enforcement, which is a difficult place for many people to turn to in the first place. The Idaho Human Rights Commission itself is severely backlogged. My case, the case that I mentioned, the library case, was filed almost a year ago, and the investigator hasn't even had an opportunity to get to it yet. And so our EEOC process for Idaho, our Human Rights Commission process for Idaho is slow. And as we know, justice delayed is often justice denied. And when we see the state legislature moving measures that continue to marginalize and exclude and isolate some of these Idahoans, that mirror tells my clients a lot. And we don't even have to look at new legislation that the Idaho legislature has passed. Another case that I'm doing right now involves that same statute that was the principal instrument of the Boys of Boise witch hunt, the crime, what's called, what Idaho calls the infamous crime against nature, a law that was overruled by the Supreme Court in Lawrence, but remains on the books. In fact, one of the things that I did early on when I was legal director is had to send a letter to the Kootenai County Sheriff a whole decade after Lawrence to explain that gay sex is not in fact criminally or constitutionally criminalized in Idaho anymore, and it's not anymore anywhere in the country, but that law still sits on our books. And years after the Lotta versus Otter decision, we still have, both in our Idaho Code and in our Idaho Constitution, an unconstitutional law that limits marriage to a man and a woman. So we have a situation where in Idaho, this mirror that our government holds up to our society tells us where our rights are to be found, and it has a real impact on our clients. The enforcement of these basic human rights is often really left to the individual, and few of these folks have the wherewithal to navigate these systems on their own. The delays on their own are overwhelming, and there's very little capacity for organizations, including the ACLU, to assist. What we need is more than just the courts and some of our communities to change this mirror. We need the whole government to embrace this. And I think I have seen that, and I have used those tools that the legislature has given us to protect religious freedom. It's a much more difficult task when I am trying to help someone just assert and protect their basic identity, their basic gender identity and sexual orientation. So from that place where the law and humanity collide, that's my report. I'm pleased to be a part of this panel. I'm interested to hear what everyone else has to say and interested to see the questions that come. Thank you for the time.
Thank you so much. And next we are going to hear from Senator Ricks.
Yes. Hello, everyone. Can you hear me okay?
Yes, we can hear you.
Okay, great. I switched and put my headphone on, and I just want to make sure you could hear me. So I'm happy to be on this panel this time. I feel like I'm probably the one that has the least knowledge on some of the particulars of the law, even though I am a state legislator. However, I do have interest in obviously the subject for protecting the rights of LGBT folks, and also religious freedoms. I was raised in a strong Christian home, and I still am a Christian. I believe in those Christian values. However, I do have a son who is gay, and so it's been a process for me to understand a little bit more from his viewpoint of what's going on, and understand some of the discrimination and some of the bullying and some of the troubles that he's dealt with over the years. Has helped gain, for me, I believe, a little more perspective on the issue. As a lot of Christians are, they're taught very strong about marriage being between a man and a woman at a very early age, and that's ingrained into, at least in the religion I belong to. And it was difficult for me as a parent to kind of grasp with terms and understand with my son that he genuinely has natural feelings for men and not women. And that process has kind of led me to, again, to learn a little more about it, to do some inquiring with some counselors and others, even within our church. And all of them tell me that, yeah, this is, you're not going to change him. That's how he was born. And those feelings are very strong, and, it's very unlikely that they'll ever change. And so that's helped me to kind of be a little more understanding. However, in talking to a lot of my friends and others and associates, it's not as easy for somebody who doesn't have a member within their family or extended family or something that is gay to kind of help come to terms with this. I do find that a lot of the children, a lot of the younger generation, don't seem to have a problem with it. They understand that they know in school who is and who's not, and quite frankly, most of them, at least that I've seen in a large scale, don't really have a problem with it. But it's the older generation, it's us, that they're trying to grasp and figure out how to make a balance with this. So one thing that's helped me a lot is, and I know I want to talk about the process of policy change in Idaho. Idaho is a pretty strong conservative state, and our legislature is made up of members, a large percentage is Republican, and most of us would consider ourselves as pretty conservative. However, I see within the state kind of two extreme views, so to speak, when it comes to politics. You have your far left and your far right, and those are the groups that are at the biggest odds with each other, not only in just regular legislation, but especially it's brought out when it comes to human rights issues and LGBT non-discrimination type things. And so getting, and both of those groups are very, very loud and have a lot of influence on certain types of legislation. And so therein lies some of the conflict that we go through as legislators on a lot of legislation, but especially this type of a thing. I am, as a policymaker, encouraged to see some of the things that have happened on the national level, which are moving to make things a little bit better, because it would be difficult to make certain policy changes on the Idaho State Code. So there are some national things, as was brought out by some of the prior speakers, and I appreciate that. And I'm also here to learn too at this summit myself. I don't have all the answers, but as a legislator, I'm willing to listen and to look. I did follow, well, Senator Hill, who was in the seat prior to me, did pass on to me some of his information that he had gathered over the last several years. And a couple of years ago, he actually did do a draft of some legislation that provided, some changes or that would help. So there was non-discrimination in the workplace and in housing and other situations, but also provide some protections for religious freedom as well. And I know in visiting with him in the past, he has said that sometimes it's hard to get both sides of that issue to come together and find some common ground that they're comfortable with. Sometimes they would get close, he said, and then one or the other group would go back, and then it would, to their people, and it would come back, and then there was kind of an impasse, and some on a little bit different types of middle of the road policy, so to speak. And so I'm actually again willing to listen and to try to figure out if there is some paths to move forward on some of these kind of issues. In Idaho, you've got 105 legislators that you've got to convince a majority in each body, 48 in the House and 24 in the Senate. And then you've got to get one governor to sign it as well. But in the meantime, the whole process, legislative process, is complicated because you have hearings in each body, and you have a lot of folks that come forth, and it's on certain issues, it's not necessarily easy to get those passed, as a few things that will help, I believe, is trying to keep the dialogue civil. There's nothing more frustrating, especially as a lawmaker, to have people attack you vigorously on social media or emails or in person on particular subjects, and then want to turn around and be willing to work with them. The civil discourse is the best route to go. And if people can come together and truly have discussions that are productive, that there's no name calling, that there's no labeling, that you can sit down and really discuss the ideas and be open with it and figure out plans that, again, would protect the religious freedom, which are important to me, and the rights of the LGBT community. I do think there is some compromise that can happen, and that we could move forward with this. I think it is an important issue. Certainly on the federal level, there are steps that have taken place that are good, but I think there probably is some additional legislation Idaho needs to look at. But it will take, a lot of effort to get the majority of the legislators behind something like this. And civil discourse is the best way, that is probably the only way we can get this done. So that's pretty much all I have. And I'll pass the time to the next speaker.
Thank you, Senator Ricks. Our next speaker is Misty Tolman.
Good afternoon, everyone. I almost just said good morning because I'm just in good morning phase, apparently. I apologize. I've been speaking all morning, so my voice is a little bit coming in and out. So I'll do my best here. But my name is Misty Tolman. I use she, her pronouns, and I'm here to talk a little bit about the history of Add the Words in Idaho. I do want to say that I in no way can speak for or would ever attempt to speak for or represent the entire LGBTQ community in Idaho. Obviously, like any community, we are not a monolith. We're a group that holds a lot of different experiences and a variety of opinions. But the one thing that seems to be a constant and hold constant across the board for a majority of queer and genderqueer Idahoans is the discrimination or threat or fear of discrimination that we live with. We are coming up upon decades of work by LGBTQ activists and allies. We sit on the shoulders of incredibly brave souls who helped build a foundation of understanding so that we can sit here today and talk about these issues. I'm currently the state director for Planned Parenthood Votes Northwest and Hawaii, and as such, I feel honored and lucky to be able to continue to work on these issues that not only align with our mission, but are also so near and dear to my heart. Before I was with Planned Parenthood, I want to rewind a little bit to my coming out. I was raised in a very conservative religious household and tried for decades of my life to live up to the gendered expectations that I was being held to, and that a lot of folks in those communities are held to, until I no longer could. This resulted in my coming out at the age of 30 as a divorced mother of 4 sweet, loving children. I immediately felt pulled to work to, as I saw it, kind of atone for some harm that my religion had caused the LGBTQ community over the years. And I found and joined up with a group of activists who were working on some anti-bullying legislation at the time, and also some workplace protections for the LGBTQ community. We pushed a number of high-profile campaigns, and were successful in kind of elevating the issue in front of more people than it had ever been seen before. But even after many years of this, we were unable to receive a public hearing. There's something a little bit unique about Idaho in that we have print hearings before we can have public hearings. And so it can be an added barrier to be able to get voices inside the State House. And we felt really strongly that we needed to get these voices inside the State House. One morning, a small group of us met at a coffee shop and formed a more formal, all volunteer-led group and media campaign that we coined Add the Words Idaho, that sought to do just that, to add the words sexual orientation and gender identity to the Idaho Human Rights Act. And of course, there were, over the years after that, there were fractures and a variety of opinions and a variety of different efforts and angles that were taken. And eventually we were able to secure a public hearing. So during the first and only in decades, public hearing we ever received in 2015, we sat through days of hearing myself, my friends, my family, people I love, being referred to as pedophiles, as criminals, having our character questioned, having things said about us that were untrue and salacious, accusing us of really horrible things, and truly forcing us to have to stand there and try to prove our own humanity and prove that we deserve to exist. It was incredibly disheartening. Up until this one public hearing, the legislature had blocked Add the Words from ever receiving a hearing for 9 straight years. And then this was the hearing we got. However, over 4 days, we heard over 20 hours of powerful testimony as well. We heard 134 people speak in favor of adding the words, with only 54 against. It didn't matter, though, unfortunately, to those 13 members of the House State Affairs Committee in 2015 who voted against this. And the comments themselves during that hearing were truly they showed themselves, the comments themselves showed the need for updating the Idaho Human Rights Act. The vitriol and hostility that was shown toward the LGBTQ community in those 4 days showed that need. So I was there then, and I'm here today as your sister, your sibling, your mother, your daughter, your aunt, your cousin, your neighbor, your friend, so many people who are LGBTQ, whether they are out or not. You know us and smile at us when you pass. We work together, you work with us, you conduct business with us, yet we are not extended the same freedoms and protections under the statutes of Idaho as everybody else. And nobody should have to live with that fear. No one should have to live in fear, in daily fear of losing their jobs, of losing their housing, of being denied public accommodations. I lived with that fear myself as a young mother, newly divorced, needing to find work. I was able to secure a job, and I can tell you that for 1.5 years, I lived in daily fear of being terrified that I was going to be found out by my boss, or even my coworkers who could then tell my boss. So much so that I often withdrew from personal conversation at work whenever possible, working harder than ever to perform my duties so that I could keep my job and provide for my children, but unable to fully engage or participate in my occupation for fear of having to get into those personal conversations and consequently end up losing my job. I had no pictures of my family at work. I didn't talk about my weekend if I could avoid it. If I was forced to answer direct questions, I would leave my partner out of my answer or try to, it makes me feel ill now to think about it, but try to switch pronouns with people and then try to keep my stories straight of who I told what to. And it really ends up that these normal, seemingly innocuous questions, while people are just trying to get to know one another, become in your head a matter of having a livelihood or not. I'm sure that at times I appeared disconnected and uninvested in my work, and it couldn't have been farther from the truth. Our forefathers believed that no artificial impediments should hold anyone with ambition back, that every American must have the right to achieve their American dream with no contrived man-made obstacles. And yet that's the reality for thousands of Idahoans. No one should have to live under that stress. I can tell you that it's too much to bear. The simple question before the legislature then and before us still today is whether gay and transgender Idahoans must continue to live without the same protections, must continue to live as second-class citizens. And every day that Idaho fails to act is another day that gay and transgender Idahoans have to live under a system that legalizes and codifies harm against them, and for them to be able to have to live in fear each day. I do want to stress and remind folks that the Human Rights Act, the Idaho Human Rights Act, does protect businesses as well as individuals. The Human Rights Commission, while Richie mentioned, is bogged down but they do investigate and mediate claims of discrimination to also make sure that discrimination actually occurred and that there, it protects businesses against false allegations as well. Over the years, we've heard a lot about, and there have since been Supreme Court cases, but we still hear about it when we're having these conversations with lawmakers. We hear about protecting the cake baker. We hear about protecting the photographer. And the point from opposition has been, protecting people with sincerely held religious beliefs. And one thing that has continued to stand out in my mind is from that public hearing where we had a local rabbi, Rabbi Dan Bink, stand up and say, we never hear about the Jewish cab driver refusing to give a ride to someone eating a ham sandwich. We never hear about, for instance, an LDS hairdresser refusing to do someone's hair who's drinking coffee. Why are we only hearing about sincerely held religious beliefs when it comes to discriminating against the queer and trans community? And honestly, in those points, as a gay person, it begins to feel like religion is being used against me as a sword. And the Idaho Human Rights Act has exemptions for religious institutions. Those already exist. It already strikes the balance between protecting religious beliefs and protecting people from losing their jobs and their housing and being denied public services. And we also have a ton of support for these protections. We've worked for decades to talk to people, to talk to communities, to talk to the public. And at the time of this hearing, the latest polling coming out of Boise State showed that 67% of Idahoans believed that gay and transgender Idahoans should not lose their jobs, should not lose their housing just because of who they are and who they love. We had an op-ed at the time from beloved former Republican Governor Phil Batt. We had Bill Roden, a well-respected ex-Republican legislator and lobbyist, present at the hearing. We had the director of the Human Rights Commission there to review the commission's role and the investigation process. We had, at the time, the chief of the Boise Police Department there testify about what it had been like, because Boise had recently passed a non-discrimination ordinance. And so he was there to, testify that the sky had not fallen and the sun continued to rise even after passing this NDO. We had a dozen different clergy members from various religions testifying in support, a number of organizations working on human and civil rights. We had businesses there to talk about the challenges of bringing businesses to Idaho and bringing workers to Idaho when they knew that their workforce would not be protected, that these protections did not exist, including Chamber of Commerce and the Boise Valley Economic Partnership. Like, this is just a sample of the breadth of support we had for these statewide protections. The legislature has passed legislation with far less support than the support we had for Add the Words in 2015, and that support has only grown. Lastly, I just want to say that, I've also heard folks say that, my niece or my friend or my uncle says that these protections aren't needed. And I will be the first to say that I am so glad if there is an LGBTQ person out there who is not facing discrimination, who has not experienced this and has not experienced that fear. But just because one person has not does not mean that the rest of us don't deal with this reality every single day. A strong majority believes that it should not be legal to fire someone because of who they are or who they love. The legislature has a lot of really tough issues in front of it every year, but this isn't one of them. This is an issue that there's nothing to lose and everything to gain. And to me, it boils down to the golden rule. And I can't think of anything that's more family values or in line with religion than that. We have since turned our sights to cities in light of the state refusing to act to protect its citizens. The most recent city was Meridian, joining 12 other cities who have enacted non-discrimination ordinances. So now we have the 2 largest cities in the state that have NDOs. Like Richie alluded to earlier, Ada County recently also passed an ordinance protecting LGBTQ citizens in its unincorporated areas. And this is great, and it's something we're going to continue to do as well, so that we can at least protect as many folks as we can. But it also kind of creates a patchwork of protections that's confusing and difficult to comply with. For instance, if I live in Meridian but work in Nampa that doesn't have any protections, or vice versa, you know, what does that look like, and who's complying and who isn't, and where am I protected and where am I not? So yeah, I guess my biggest wish in this fight, as we continue to try and make sure all Idahoans are protected, is that the religious community could join us in working to protect all Idahoans. There's protections that have existed for decades for the religious community, and it's past time to make sure that we're protecting some of the most vulnerable among us.
Thank you, Misty. I appreciate that. Appreciate your thoughts. Next we have Tyler Deaton.
All right, thank you so much for having me. It's been great listening to all of the different thoughts that people have already shared. I'm especially grateful, Senator Ricks, for you sharing the story about your personal family and for wanting to protect your son. I think that's really powerful. I'm not a lawyer. This seems like a very lawyerly crowd today, so I've got to just be upfront with you. I am not a lawyer. I am a lobbyist. I'm a political operative. I think some people would call me just a political hack. I think I'm probably the dumbest person speaking on this panel today, but I'm happy to share my perspective for whatever it's worth. I'm a gay guy from Alabama who has worked my entire adult life to win the freedom to marry nationwide and to win comprehensive non-discrimination protections for gay and transgender Americans across all 50 states. And so I just want to start by talking about the Bostock decision and really what I think it means, what my organization, American Unity Fund, thinks that it means, and where we go from here. Because I've also already been checking out the Q&A, and I saw there's one question. It's kind of like, well, so after Bostock, what is the point of a add the words bill? And especially like what would that mean for federal legislation like the Equality Act? So Bostock means that, or at least we think it means, I'll leave it at that. There's a lot of litigating still to do. We think it means that eventually gay and transgender people are protected in employment and housing, in the Affordable Care Act, in Title IX, anywhere where sex is protected by Congress and by federal law. We think that it will ultimately mean that sexual orientation and gender identity are also protected. That is going to be years, if not decades, of litigation trying to sort out what that all means and then what it means in those particular contexts, like the Affordable Care Act or like Title IX, each of which, you know, these laws all have different kinds of religious exemptions already embedded in them. But there's other huge areas of federal law that don't protect against discrimination based on sex, let alone sexual orientation or gender identity. And the 2 biggest examples of those would be federal public accommodations law and federal funding, which is Title VI of the US Civil Rights Act, just kind of the background law of non-discrimination in any federally funded program in America. So you have huge areas where sex is still not protected. You have evolving law in those areas where sex has been protected. You have a conservative court that has said that at least in employment, sex includes sexual orientation and gender identity. We wonder, you know, in Gorsuch's opinion, there are already these kinds of references to religious freedom and what it could portend down the road as the existing co-religionist exemption that's in Title VII is litigated out, and as other things like the ministerial exception and RFRA are litigated out. I don't know. Nobody knows. Nobody can really say for sure how this all plays out in the courts over the coming years and decades. But see, this is where me being a lobbyist maybe this perspective is helpful, because I think that we don't have to have that kind of uncertainty. Congress and state legislatures could do their job and pass these laws with total clarity so that I and my husband can travel around the country and know that we're protected, and we can know what it means, what it doesn't mean, when are we protected, and possibly when are we not. And just to have that kind of certainty, that clarity, the ability to plan, the ability to move freely around the country, the ability to take a job in another state, not have to worry, you know, what could this mean? It resonated for me what Misty said about having to go from Meridian to Nampa. That kind of uncertainty is something that I want everybody to understand is a constant presence in the life of an LGBTQ person, especially somebody who's living in a more conservative area, but I would argue that it's common around the country. Now, taking off kind of the political hat, I just want to talk a little bit about empathy, because half of my work is lobbying Republicans to be more pro-LGBTQ. The other half of my work is lobbying Democrats to be more supportive of religious freedom. American Unity Fund, my organization, is a conservative-leaning group. We run American Unity PAC, which is the largest LGBTQ super PAC in the country. And what's unique about it is that we exclusively work to elect and re-elect pro-LGBTQ Republicans to Congress, because we recognize that that's the political reality of our moment. And that's something that we want to help Republicans who are pro-gay and pro-transgender have political success. But empathy, the ability to see that people who disagree with us have the exact same freedom of speech, the exact same freedom of expression, the exact same freedom of religion, that's core to what American Unity Fund is all about. It's just core to my own beliefs. My desire to protect people who think my marriage is sinful, I want to protect them too. I'm willing to protect them even if they're not willing to protect me. I think that that's what's required in a pluralistic society. And then we just have to keep educating and persuading more voters to side with us. But what I have learned in my work is things like, I mean, there's just like this one example that I've learned from my friends in the Orthodox Jewish community, that there are years when the calendar of holy days is such that they see an uptick in more Orthodox Jews facing employment discrimination because they're asking for more time off on weekdays rather than on weekends, for example. That it's just, there's years where even just the nature of the calendar means that Orthodox Jews face more discrimination. And that's appalling. And what I've learned from that is that there are a lot of ways that society mistreats religious minorities and LGBTQ people in very similar ways. And that makes me have a lot of empathy for this discussion around religious freedom, because I don't think that religious freedom is really just about these huge, big institutions that we all know have big political power and represent large populations of people who have lots of money. Like, religious freedom is also about the people who don't have money, who don't have hugely influential institutions, whose views are very unpopular, whose practices are culturally obscure or different, and they face a lot of discrimination for that. And whenever I'm thinking and describing all of that, I'm thinking of our own experience as gay and transgender people, of how we've been ostracized for having views that were unpopular, having practices that people judged and condemned and didn't like. And it's hard for me personally to wrap my mind around it sometimes, because I know that I want to protect those religious minorities. And I know that that entails protecting everyone's religion. It entails protecting everyone's religious freedom, the freedom of people to disagree with me strongly, the religious freedom of people to be members of very big religions, religions that are politically powerful, but that they deserve that freedom too. I just want to close talking a little bit about why we still need these laws. It's not just about public accommodations, right? I've mentioned that sex is not included in the federal law for public accommodations, but it's not just about that. It's not just about codifying these decisions and extending them. For me, it's also about bringing along the culture. I think we should have conciliatory political processes. I think that we should find common ground. I think that we should be incrementalists. I think that we should accept compromise. I think that we should pass laws working with Republicans and Democrats where we find that common ground and leave the rest to do at a later date or possibly never, but that it's worth it. Your bordering state of Utah in 2015 enacted a comprehensive housing and employment non-discrimination law for gay and transgender Utahns that also protects religious freedom. I think that that is a wonderful template for a state like Idaho to look at for how you can also have that kind of success which now today, Utah, if you, and I could also drop this link into the chat, but the public polling today shows that Utah is tied with Vermont for the second highest level of support for LGBTQ non-discrimination laws in the country. And that means Utah is polling higher than California, than Washington, than Hawaii, than, I don't know, I mean, we could name, I guess, every other liberal state. But I hope you take my point that because of the process itself, not just passing the law, which is important, we need legal recourse for our people to be able to be protected and go to court when they are wronged, and to hire any number of you lawyers on here to go and help represent them and get them justice. We need the laws, but we also have to change hearts and minds. And there's a way to change the laws that are more effective at changing hearts and minds. And we've seen that in Utah. We've seen a law that works. We've seen religious freedom protections that are durable, that stand up over time, and that bring the public along to the point that, again, today, Utah and Vermont are tied for the second highest level of support for LGBT non-discrimination laws in the country. And to me, that sort of says it all. And I would commend that approach to all of you. I'm not in Idaho. It's actually one of the 4 states that I've never visited, just to be totally honest. I've never even been to Idaho. I would love to come to Idaho. And so with that big disclaimer, I just want you to see that it can be done. And I say that to Republicans and Democrats and independents and progressives and anarchists and Green Party, anybody, that there is a way to do this. It's been done in a neighboring state that I think has some pretty similar politics. And I just would encourage you to find that solution, and that it's worth doing. And it's worth everyone giving up a little bit of comfort to do it that way, that it's worth it to be able to live in a society where pluralism and diversity of thought, where sexual diversity and religious diversity are both equally celebrated and protected, that on the other side of it, you'll live in a healthier, stronger, safer, happier state.
Thank you, Tyler. And finally, we're going to hear from Brian Grimm.
Well, good afternoon, everyone. And unlike Tyler, I have been to Idaho, but I'm not speaking to you from Idaho. I'm just outside of Washington, D.C. So I'm the president of the Religious Freedom and Business Foundation. And I'll mention at the start that we don't take a position on current legislative initiatives or debates such as the current one occurring of the Equality Act in the U.S. Congress. But however, there are 3 points from our research and our work that I think provide examples of how religious freedom and the rights of LGBTQ plus people both benefit from societies and workplaces that are diverse, inclusive, and equitable for all. So first, given the heated culture war rhetoric, this divide that Tyler was just talking about, it may come as a surprise to many people that the majority of LGBTQ plus people are religious. So some of the survey data shows that almost half of LGBT people in the United States in particular identify as Christian. 6 in 10 LGBT people identify as religious, including other faiths. So to have a workplace that's religiously inclusive and non-discriminatory is, you could say, as important to many LGBT people as it is to straight employees. So that's the first point, that this false dichotomy that religious rights don't matter to people in the LGBT community. It's just not true. I'm straight, and I'm a straight white guy. I have friends who are LGBT and very religious. So as I work with them on different issues related to religious freedom, even their sexual orientation doesn't come up. They're working for religious freedom. So as I work with people and look at the data, I'm a data scientist by background, that divide is in many ways not the right divide that we should be talking about. The second is I do a lot of work with bigger companies, so Fortune 500 companies, Fortune 100 companies. And what we've found is that building an inclusive workplace for LGBTQ plus people, and at the same time for people of faith within the same workplace, works. You have faith groups and LGBT groups, pride groups, working in the same space, and in fact working together in some of the most diverse companies in America. So Tyson Foods, CVS Health, American Airlines, Dell, Intel, Target, Salesforce, Texas Instruments, PayPal, Accenture, Equinix, SAP, American Express, and many others. They have both employee resource groups for people of faith. Either they have interfaith groups or faith-specific groups. And they also, like Intel, they have a group for atheist agnostics within that faith and belief category. And at the same time, they have a pride group for employees. And they work together. Walmart, the largest employer in the US, has had a pride group for many years. And it's only in the last couple of years that they've added a faith group. So as we talk about this issue of sort of inclusivity in the workplace, there's been really a big push in corporate America, in the big corporations, to do their best to make people, regardless of their sexual orientation, feel welcome. But religion, for many years, has been sort of the you could say the elephant in the room, or whatever you want to call it. But many companies have shied away from welcoming religious diversity in the workplace. But that's really changing. So when Walmart stood up their faith group, it's called FAVOR. That's an acronym for Faith, Vocation, Opportunity, and Reality. And the mission of that is to connect, collaborate with, and celebrate associates of all faiths to make a difference for the company, their customers, and their communities. FAVOR's purpose is to promote understanding, acceptance, and inclusion by encouraging associates to appropriately integrate their faith at work. So one of the reasons that in corporate America that we can have faith groups and pride groups working together side by side is that they have a common mission. That's to support employees in the company, and ultimately, and really mainly, to support the company. So their purpose is not to proselytize or to advocate for one right above another, but it's to help that company succeed. So when you have that common mission, then that brings people together. And I think it's just such a beautiful example for our society in general, that these things that create divisions on, sort of in the political sphere especially, and in our rhetoric, inside of these great companies, there's just so many great examples of things issues that divide actually bringing people together. So I'll just give a couple examples. I was on the phone today, this was in the UK, with a health provider in the UK. It's a Catholic group, and they're starting their employee faith group, but they've had a pride group for years. And they said as they're starting their faith group, the pride group is really interested to help because the head of the pride group is a practicing Catholic. And so that person is helping the pride group, the faith group get set up. That's the kind of story that, you know, many people would scratch their head and say that that doesn't sound right, but these stories are happening. So just a couple other examples from corporate America. Texas Instruments was really a pioneer in having faith at work, but their pride group was set up about 21 years ago. And about 20 years ago, their faith group got set up, and the company was worried that, well, is this going to be a conflict? So they got the head of the pride group, the head of the Christian group, which was the first one to get set up at Texas Instruments. Now they have others as well. And the two of them became best friends and went around the country talking about why having a workplace that recognizes the core identity of people, whether that, you know, for some people, their faith is their core identity, and that's the most important thing to them. So that shouldn't be left outside at the door. You know, you got to keep that outside of work. No, instead, they encourage people to bring their whole selves to work. And it's Texas Instruments considers that to be one of the main sort of pitches for new employees. Come bring your whole self, whether that's your identity's LGBTQ plus, or it's as a Christian or a Muslim or a Jewish person or Hindu or whatever it is, bring your whole self to work. So these are, I find that to be helpful. I realize when you get to smaller companies, things work a bit differently. You don't have as much diversity, but these large companies are really charting the way forward. The last point I'll make is that I mentioned that I'm a data scientist, and so we did a global study a couple of years ago, looking at levels of religious freedom in countries and comparing it with LGBTQ acceptance in those same countries. And of course, as I indicated, given the cultural rhetoric, you'd assume where there's more religious freedom, well, the culture war would say, well, there's going to be less acceptance of LGBT people, and vice versa. Where there's more LGBT acceptance, you're going to have less religious freedom. But the data are just the exact opposite. So the data show that countries that have more support for religious freedom also have more acceptance of LGBT people. And vice versa, where you have more acceptance for LGBT people, there's more religious freedom. And we looked at the study to see which way are the trends going. So where religious freedom's increasing, what's happening to LGBT acceptance? It's also increasing. Where one's decreasing, the other's also decreasing. Now, that's correlation, as rightly as said, correlation does not mean causation, but it's very provocative. Well, these two things work in the same direction. So the data suggests that these do not have to be in any way in conflict. Like in Utah, where you had the Utah Compromise for shorthand, they were able to see how these two rights could advance together. So with that, I'll just close by saying that I think there's a lot of hopefulness in these kind of findings, and I hope they spill over to our society in general. Thank you.
Thank you so much. And thank you to all of our panelists for your initial incredibly thoughtful and thought-provoking comments. We're going to transition now to some questions and open discussion. And I want to lead it off with a question that I hope faithfully encompasses what a couple of the questions submitted by the audience are asking, and one that I was hoping to get answered. I'm a pretty practical person. I like to have some practical, tell me what to do things. And kind of building on Tyler's comments and building on Brian's comments, how do we preserve both communities' rights under Title VII? Or put another way, how do we work together to prevent further conflict, communicate better, and protect each other's rights as we're each working to solidify our own protections? And I feel free to jump in, raise a hand, however you feel comfortable if you'd like to talk, but I'm putting that to the whole panel. I didn't mean to stump you. But I will note, maybe as a jumping off point, Tyler really got me thinking this was a fantastic question, because at that end made a very specific pitch for ways that we should be speaking to each other, using the Utah legislation as an example. And I really enjoyed Brian's examples of the more inclusive workplaces, bringing your whole self, and how that actually benefits us.
So I'll jump in with one other thing. Something that the companies are doing, and I think it's really productive, is give an example from Salesforce, a big content management company, one of the fastest growing companies in America. 3 years ago, they set up their faith group called Faith Force. And it's now the fastest growing employee group in the company's history. And one of the initial meetings that Faith Force had was something called multiple closets. And so in this multiple closets, they invited 3 LGBT people of faith to come and talk about what it was like to come out as a religious person and as a gay or lesbian person. And it's sort of the consensus that a number of companies have had these kind of events, and I know some companies that are having them just in the coming weeks. And what's said is, they say it's harder to come out as a religious person in in these big corporations, because there's been so much emphasis on making LGBT people feel at home. Then to come out as religious was harder. My point isn't that, but my point is that they're jumping in and talking about this directly. They're inviting people to have the conversations just like we've had today. So when you don't talk about things, then you put them under the table, and then all you do is you suspect, oh, I think they think this about me. And I'll just end with this one. We did a training at Accenture, a global consulting company, and it was on how to make your workplace more religiously accommodating. And one of the participants was a gay guy who's not religious, but he grew up in a Christian home. He was rejected when he became gay. He was hurt. And then he just thought all religious people are bigots. And, he just had such a bad taste that whenever he encountered somebody who was religious, it was like, get away from me. He came to the meeting because he said he just feels like he might be biased, and he wanted to hear what this religious accommodation was all about. And by the end of the meeting, he said, I've wrongly stereotyped a lot of these religious people, and my worldview has changed. And for the past year, he's been talking about that changed worldview. So, it's sort of this mistrust goes both ways. There's a lot of people in the LGBT community have been hurt by religion. A lot of religious people feel like, they don't know how to get their heads around this. And I think having venues like you've organized today, congratulations for this, are what's needed to talk about this in honest terms.
Would anyone else on the panel like to expand on that, or?
Yeah, I'd be happy to speak to that. First of all, I couldn't agree more with what Brian just said. I think as a practical matter, that is 100. I couldn't agree more that is the answer. In terms of how the law, though, should balance these interests, I want to start by noting what we all agree on, which is that, first of all, I'm going to say something that I really never thought I would say, which is I think that Justice Scalia got it right. I think what we can all agree upon is that in a pluralistic society, the law should strike a balance that protects the fundamental rights of all people, which includes the fundamental rights of the LGBTQ community, as well as the right to be free from discrimination on the basis of religion. But allowing exceptions to laws of general applicability for one group at the expense of another does exactly the opposite. And the way to strike a balance is to say that the law should apply equally to everyone. Otherwise, you have a slippery slope that's harmful to religion and to religious minorities, as well as to other protected groups. It is not for the law to pick winners and losers, basically. we're not providing a special privilege to the LGBTQ community by protecting against discrimination. That's not winning. That's being treated the same as everybody else, including religious minorities. And that was the insight of the founding fathers, and it was the insight of Justice Scalia when he wrote Employment Division versus Smith. And to Brian's point about the data that shows the greater the religious freedom, the greater tolerance, Alexis de Tocqueville noted the same thing at the founding of the Republic, that there was actually greater, that religion actually prospered when there was greater tolerance, and that was sort of the beauty of the American experiment. So I would say we've struck the right balance, and Bostock, and I think also strikes the right balance. And so I look forward to seeing these statutes that borrow from that language continuing to recognize that discrimination on the basis of sex does extend to discrimination and inexorably includes discrimination on the basis of LGBTQ status.
I don't want to step on anybody, but I kind of have a follow-up question that was asked in the Q&A. And it kind of combines both Kim and Brian's comments in terms of, if we're having, like in that employment setting, that open dialogue and having everybody come out of the closet. I will just note that it was harder for me to tell people that I came from a Jewish/Jack Mormon background than it was than for me to tell people I was gay. So I'll endorse that particular approach. How do we have those conversations when we're all just a little bit afraid of offending each other or saying the wrong thing and being branded a bigot, being branded intolerant? Because we might have some notions that we don't yet know are inaccurate, or I've had some outright ridiculous notions in my time and find out later how embarrassingly bad those were. How do we have those conversations and feel like we're safe to do that? Anyone?
So I put this in the Q&A, but also I just want to say that in my experience, most LGBTQ folks are quite forgiving when they can feel a sincerity from someone talking about these issues. Like if someone is just stumbling over words or how to say something, or truly don't have the language yet to know how to talk about something in a sensitive and inclusive way. I feel like in my experience, I can't speak for everyone, but in my experience, most are willing to kind of help someone along the way, meet them where they are and help them come along. I used the example that my child recently came out as trans and non-binary, and I've known them, their entire life up until then. And so I still sometimes slip up with pronouns, and I just correct myself and keep moving on. And, we've had a conversation about how that feels to them, and that's the best way for us to continue that conversation. And I feel like it's one thing to be intentional and to be earnest and genuine in your attempt to talk about these issues in an inclusive way. And I feel like most LGBTQ folks can feel that and are wanting to help. And I dropped my contact information in the Q&A. I'm happy if people want to reach out to me with questions about how to talk about issues that they know might be coming up in their lives that are a little bit sticky for them, or they may not have the language for. I'm happy to help have those conversations, and I'm sure there are others as well. But I don't think there are many people who are out there just waiting to have a gotcha moment with someone, to just be like, ha, you're canceled. If they can feel that somebody is truly wanting to learn and come along, I feel like most people are willing to meet in the middle and come together. Those are my thoughts.
I'll just throw one other in. We had big conference with Fortune 500 faith groups coming together to talk about their experiences. And one of the sessions was called Greater Sensitivity and Thicker Skin. And I think that, Misty, just what you were saying, there's the importance of having greater sensitivity and trying to get the language, but also that need to have thicker skin and not get offended so easily when people make mistakes or don't understand different things. Of course, I don't understand a lot, and so we all make gaffes and have incomplete knowledge. So I think there's two, always balancing that, that nobody's ever going to get everything right. And so we have to have thick skin to not be offended so much, but we also have to do our best to be sensitive to others.
John, I feel like you would like to chime in.
Oh, it's actually to a question that was posed to the panel as a whole, and I believe is also put in the chat, which was the question was why should there be a carve out? And I believe those were my words, so I'll try to field the question first and invite other panelists to come in. Why should there be a carve out? For religious entities who have a free exercise right, why shouldn't they be able to exercise their religious values both inside and outside the workplace? Here's my thinking. That in a pluralistic society, the way we are, at least in terms of our values, I think we all individually and professionally have a hierarchy of values, and some values are more important than others. So I'm not surprised. I didn't know exactly that I was doing it, but I can say that in my value structure, while I very, very much value free exercise of religion, and I put that as a very high value in my structure of values, ultimately, I probably value equality and equal treatment. And I tend to side in my both personal and professional beliefs in dealing with people who maybe have a little less power. And so when I look at those two competing values, I make the value of equality and lack of oppression as the norm, and then say, should we allow, a religious carve out, to occur? Someone else, perhaps the questioner, would say, well, no, we should have more of an absolute right into free exercise of religion. And so we should exalt that. Why should you force us to carve into our free exercise rights by engaging in practices, including protecting LGBTQ rights that perhaps we don't put as primacy? So that's my first thought on it. My other thought is that I think the legalistic answer, but I think the answer that resonates with me, is that almost all of our constitutional values are not absolute. We indeed say that when there's a compelling governmental interest, even when there's discrimination going on, which occasionally can happen, we will indeed, if the interest is strong enough, allow an incursion on even constitutional rights. So that's kind of where I come at it. I'm sure someone else who looks at it, who puts a greater premium on religious freedom, might slice the bread in the opposite direction. But I think I think I'm putting a priority on that. That doesn't mean I'm being absolutist about it. And I just look at it, as I mentioned at the end of my talk, my sense, given my priority of values in this pluralistic system, and given the myriad already of constitutional carve-outs and statutory carve-outs for religion, my balance comes in terms of favoring, if we have to absolutely favor one over the other, protecting LGBT rights under the Bostock decision.
Well, and there's a number of questions out there. I mean, first of all, thank you, John, and thank you, questioner, for that question. There's a number of questions still pending there, but we do need to wrap up. I'm going to just say briefly, thank you to the panelists Thank you to the questions that we have, the thoughtful questions and the equally thoughtful answers and response by the panelists. But as we're running out of time, I'm going to hand over to Chelsea Gaona Lincoln. Hopefully I said that correctly, Chelsea. I apologize if I mangled that. And thanks again, panelists.
Thank you so much, Rebecca. And thanks to everybody. I'm Chelsea Gaona Lincoln. I use she, hers, and they, them pronouns. I'm tuning in from the unceded and stolen land of the Shoshone, Bannock, and Shoshone Paiute tribes here in Idaho, now known as Caldwell or Canyon County. We want to thank everybody, all the participants today, not only you in the audience, but our panelists for the thoughtful, fruitful, and vigorous discussion and all the presentations that you gave. We hope that people will use this as a springboard, taking it back into your personal conversations, maybe not the dinner table, depending on your family dynamic, but certainly wherever you feel it is merited. For my queer and trans siblings and nibblings, I see you and I honor you holding in this space and appreciate you being here. And I just want to remind folks as a highlight that Idaho does have, I believe 11 codified protections for religions in the books. Me as a queer person and as a young mother, I have none. And I would just challenge people as they leave this space to first check in with your body, maybe roll your shoulders back. You might be wearing them as earrings. I would invite you to unclench your jaw and remove your tongue from the roof of your mouth. You probably didn't even know it was sitting there. And just take a few deep breaths as you leave this space, taking with you what you need and leaving here what isn't going to serve you. And the challenge moving out of this space, whether you exist in corporate spaces, organizational spaces, if you're a lawyer, a legislator, what have you, that sometimes every now and then as complex humans, we have a tendency to overcomplicate and over-intellectualize just the conversation when it comes to someone's humanity. So I would leave that with you just to tackle and to think on as you leave this space. And again, we appreciate you being here. And if you have any questions moving forward, you can circle back to that summit website and contact information is available. And with that, we thank you so much for your time. Take care of yourselves, take care of each other, and we will see you out there.